Thank you and good morning. Welcome to the October 8th, 2024 sitting of the Massachusetts Appeals Court. Sitting to my right is Justice Sabita Singh, to my left Justice Robert Toon, and I am Justice Eric Nyman. We will be your panel this morning. Let me set aside a few ground rules, so it'll be a minute, counsel. Each side will have 15 minutes to make their presentation. There is no rebuttal in the appeals court. We are familiar with the briefs, with the case law, with the facts of the case, so we urge you to cut to the heart of your argument and argue legal matters, not facts. However, your time is yours to use as you see fit. I would also like to welcome students here today from the Massachusetts School of Law. It's wonderful to see you, and thank you for attending the appeals court today. Finally, you will see the judges on occasion looking down at their iPads. I assure you we are not reading email, we are not looking at the news, we're not revving up for the Bruins game today. We are looking at the case law, the record in your briefs, and checking your representations in real time. Final point, when your 15 minutes is up, you will see the red light go on at the podium. When the red light goes on, your argument must stop. If we see the need or see fit to give you additional time, we will do so. Let me check with my colleagues. Any other housekeeping matters? Seeing none, we will call the second case on our list after our first hearing via Zoom. This is docket 23P 1343, DePiro versus Anketel. Hopefully I pronounced that correctly. We'll hear from counsel for the appellant. I believe it's Attorney Regan.
Thank you, Your Honor. It may please the court. I represent Mr. Damien Anketel and his company, Ground Up Construction. The appellants in this case are seeking to have the court correct an error and vacate an order for attorney's fees under 93A at the trial level. As the court's aware, 93A provides for attorney's fees for a prevailing party, but that is only in connection with fees incurred for the advancing of a 93A action. In this case, the plaintiffs had been pro se for at least 2.5 years at the time that the 93A count was added by way of a demand letter and then amended pleadings. Their original attorney, Mr. Sedin, had withdrawn in January of 2016 after having started the case in April for them. The judge below entertained requests for attorney's fees from both parties, and the plaintiffs, Mr. Smith and his wife, Ms. DePiro, submitted an application for fees, which included $29,000 some odd dollars paid to Mr. Sedin, again, last paid in about January of 2016.
Did the judge hold a hearing on the attorney fee issue?
He did not. Well, there was no evidentiary hearing on the applications.
Was there a non-evidentiary hearing?
He entertained briefs or submissions on the issue. Initially, what had happened was there was an award of attorney's fees to the appellants because it was a provision in the contract.
Under the contract, right.
And then he initially said, okay, you get attorney's fees, you get attorney's fees, it's a wash. But because we're dealing with a pro se party, I took the position, and I think the judge ultimately agreed with me, that the pro se litigant is not entitled to an award of attorney's fees for their own work. Then ultimately he said, okay, everybody put in your applications and we'll make the award.
In the application I saw, and it had Exhibit A attached to it, this is at Record Appendix page 92.
Okay.
And it had, it's Exhibit A, and it had a list of the attorney time, but no invoices were attached. Were any invoices presented to Judge Liu?
No, Your Honor, and that's a point, I pointed that out in the brief. Judge Liu's ruling allowing that said all of the charges are reasonable, all of the manpower, et cetera, is reasonable.
Except for the printer ink, which he excluded.
Looks like that, yes, Walmart. But he did not, but there was no details substantiating this. The list is simply here's the period of time that I paid an invoice for, and here's the money amount.
Did you object to that fee petition on the basis that it wasn't supported by invoices from the attorneys themselves?
I pointed it out in a memorandum, simply saying, there's nothing here other than these charges. Frankly, I didn't so much oppose the form of the affidavit as whether or not it was applicable under the statute.
Right. You made the quite reasonable argument that pro se litigants aren't able to recover fees for their own efforts.
But I can't tell you, I said, Judge, there's no detailed invoices, no.
Right.
But
the judge agreed with you, I'm not going to give fees to the plaintiffs themselves, but he did give fees for the times that they said or for the amounts that they said they gave to attorneys in connection with this.
It appears that way from the totals on that affidavit, yes, that, again, Justice Naiman just said there was one item for ink, which appears to be the only thing that he knocked out of their request. But he stated in one of his rulings what I think is the correct law, that you don't get fees, attorney's fees for your own efforts as a pro se litigant. But subsequently, in a further one of his memos, he said, if I'm wrong about that, I would give equal fees here and here. That is, he went back to the idea of this is a wash. And that's what I think is the error, Your Honor, because he found a rationalization in the amount of the fees that had been paid before there was a 93A action.
What evidence is in the record that these fees, that the attorneys worked on the 93A claim? I believe there's an allegation from the other side that all of the 93A letter and the 93A complaint, that this was all drafted by the attorneys.
I'm not aware of any actual documentary evidence there, Your Honor. The plaintiff so stated in one of their memoranda. I don't know that they stated it in any form of an affidavit. I presume that it is legitimate to say, when I brought my lawyer in and we started this case, we talked about all the possibilities. 93A is a possibility we kicked around. But the fact is he never took any action that's of record to advance the 93A claim.
Well, let's assume, for the sake of argument, that the client met with the attorney and the attorney marshaled all of the facts to develop a complaint, but didn't include a 93A cause of action. But let's assume that no additional work was done, no more facts were gathered, no additional legal arguments were made, other than the complaint was amended just to add the 93A cause of action. Would attorney's fees be appropriate in the scenario I just outlined for you?
I would say no, Your Honor, and the reason for that is the plain language of the statute. A 93A action doesn't arise just because you may have a right to do it. It does not arise just because it's a valid argument. The statute lays out steps to go through before you have a 93A action.
So if it's a Section 9 action, it requires a demand letter.
Exactly, Your Honor. And none of those hoops were jumped through until 2.5 years after Attorney Sedin left the case.
Let me give you a different hypothetical then. Suppose that the clients met with the attorneys in 2015 and outlined their case, and then and paid the attorneys. 2 years later, before the statute of limitations had run, the client then, acting pro se, filed a complaint with solely a 93A cause of action. In that scenario, would they be entitled to attorney's fees if they prevailed under the statute?
I would say no, Your Honor, because again, the statute talks about fees due in connection with the action. And I think that there is a very distinct definition of when you have an action laid out in the statute. And if you're
But it seems that under the scenario I just laid out, it is in connection with it. You seem to be drawing a temporal line, and I don't know if our case law squares with that. Do you understand that question?
I understand the question, Your Honor, but again, I would say that the mere fact that you have a reason not to have actually jumped through the hoops yet, the fact that you may eventually be entitled to pursue that theory does not render an action or inaction before you've done so a qualifying action under the statute.
But the judge found your client liable under 93A, right?
He did.
Right. So maybe there wasn't a demand letter, but your ultimately liability under 93A was established.
There wasn't.
That was the case, Your Honor. Yes,
Okay.
that is correct.
And the in connection with language does seem rather, I wouldn't say loose, but general. And I guess my question to you is, is there any precedent under any kind of fee shifting statute that forecloses an award of fees for work done preparing a claim, even if the attorneys don't end up being the ones to litigate that claim?
I've not found such a case, and I can't cite you to one, Your Honor. What I have included is the cases in Massachusetts construing fees under 93A. For example, if you have a backup lawyer and you're essentially pro se, you get fees for that backup lawyer. And the fact is there are such charges in the plaintiff's affidavit, and I'm not contesting those. But the in connection with the representative, if you talk to somebody at a cocktail party and you give a suggestion, you could do this, that, and the other thing, does that warrant saying you've represented that person in that claim? I would suggest
I guess
not.
I'd probably agree with you in the cocktail party conversation scenario, but I think there may be
Perhaps in a church supper,
difference
whatever
here.
setting is better, but
But that gets into the sufficiency of the invoices and the backup for the amount of fees.
I would agree with that. As I said, I did not make an issue of the lack of detail in the affidavit because I was pursuing the other angle. But I certainly think that that is totally inadequate to substantiate what's generally called for under the statute. Yes, Your Honor. And the other matter I'd point out is Mr. Smith is, of course, cross-appealing, and in his brief, it doesn't appear to me that he has actually contested the attorney's fees issue that we raised. He has pointed out the reason that they did not pursue the action at that time. That is that Mr. Anquetil was driven into bankruptcy, and that put a freeze on any of their additional efforts for whatever period of time. But he's offered his reason for not doing so. It's a reasonable reason. But it still leaves us with the fact that there was no 93A action until 2.5 years after the last payment was made to his lawyer. So on that basis, I suggest that he's actually conceded that point. And therefore, I would ask the court to send the matter back down for further review. Or actually, enter the order yourself. You can take that same affidavit, subtract Attorney Sedin's fees to the tune of $29,000 some odd, subtract the expenses which predate the 93A action, and let that be the award of attorney's fees. That would be our request of the court, Your Honor.
Very good. Seeing no further questions, thank you very much,
Thank you,
counsel.
Your Honor.
Is it Mr. Smith?
Good morning, Justices. Thank you. I think I'll cut right to the foundational issue, which, in our opinion, is the issue preclusion one, where we have a bankruptcy ruling that's essentially, I would say, parallel to the facts in the lower court's case. And the way I see it, these are, that's the way it was written, these are core rulings in the bankruptcy case, which the bankruptcy court has the authority to rule on and make judgments on. If they're non-core, I believe the courts can receive those and make de novo reviews and have their own say in these issues. In this case, this is a core ruling. And these
But at the end of the day, we are reviewing I believe it's Judge Liu's award of attorney's fees, which is based on his discretion. Is that correct?
I mean, I can speak on that. Is that what?
Well, that's my question. I think this is an abuse of discretion standard that we're reviewing. Is that correct?
I mean, it was mentioned in our briefs that we believe that as far as the attorney's fees are concerned,
I think that's the issue before us, yes.
I believe, I mean, the discretion with the attorney's fees regarding to what Anketel was awarded, our issue with that was essentially that a lot of those fees were incurred by actions that were not specific to the lower court action. These are filing of a voluntary bankruptcy action.
Right, but I'm talking about, Mr. Regan, on behalf of his client, filed an appeal.
Right.
In that appeal, his contention is that the judge incorrectly awarded attorney's fees pursuant to Chapter 93A to you.
Right.
And my question for you is, that's what we are currently reviewing. It's Judge Liu's award of attorney's fees, and we review that for whether or not Judge Liu abused his discretion. Is that correct?
I suppose, right. I believe that he did not abuse his discretion. And the points that we made were that although there was an absence of that, there was a space between when the lower court events took place because of the bankruptcy stay, the work had been done prior to that by our attorney. Am I getting to the crux of, I think, what you're asking? That this work had been done. Whether there was a space, did we do some of our own work? We did, but the attorney did the majority of that work, and we do have receipts and details of that. And I thought they're
But in the record before us,
right.
there's no way to tell whether the work that the attorneys did in that time frame
Right.
was related to a 93A action. Is there?
I don't believe there's receipts for that specific work.
Did you receive invoices from your lawyer?
We sure did.
Did you include those in your submission for attorney's fees to the court?
I'm trying to remember that, and I believe that we did. I believe we did. I cannot guarantee it. My wife is very much more detailed than I am, and I think we would have done that because we submitted everything else.
Because we don't have them in the record before us.
Okay.
I'm not sure I see anywhere where there is anything in addition to Exhibit A, which is at Record Appendix page 92, which contains a listing of what Attorney Seiden's hours were,
Right.
but there's no description of the work contained on there.
Okay.
It would be helpful for us to know if that was submitted to the court.
Okay, that I can't answer right now. I certainly know that we have it. I mean, I've certainly looked at it and sweated over it. But whether it was submitted in that argument, I can't confirm it.
Okay.
In terms of your issues, is your primary claim that everything has already been decided in the bankruptcy court?
I think a lot of the core issues have been decided. Abandonment, fraud in the inducement. I think that those are the key issues that, had they been included in a issue preclusion theory, would have either ended the case or a jury would have been read and instructed to look at those findings and say these are findings of facts. Anketel had a chance to appeal those after the bankruptcy ruling to challenge those facts. He did not do that. And I think what's happening and what did happen was a rewriting of history. And essentially, if the ruling stands, there's a rewriting of history. And I think that's a very threatening, my layman's view of what's happened here. They're rewriting history. Facts have been found that were unfound in a lower court. Facts found by a court of apparent jurisdiction to find these facts, and then they were unfound. I find that unsettling, and that's why we tried to introduce this bankruptcy ruling, which was dismissed, or at least it wasn't imported, or whatever the term is, by the lower court. And that's the crux, because to me that's a monumental issue. That this case had been decided, and essentially what this is, in my opinion, this lower court case is an appeal carrying over from the bankruptcy court, which wasn't timely filed because the same issues essentially are being reviewed. The abandonment of the job, the fraudulent inducement, they've been settled, and they're basically opened again, and they're being ruled on again. And
are you arguing issue preclusion based on the bankruptcy proceeding or the administrative proceeding?
The bankruptcy proceeding. The administrative proceeding,
You understand that can't be preclusive to a court?
Absolutely,
okay.
yeah.
So the the bankruptcy, what exactly are the issues that you believe were conclusively litigated?
Sure. I mean, the fraud on the inducement, I think, negates the contract immediately, which we didn't necessarily do. I believe there was an unjust enrichment count on that, just in case we were able to introduce this and have the contract terminated, which we didn't do. So then we would go after with an unjust enrichment case, which we couldn't do. So getting back to your point, I think abandonment of the project, and I believe at the Smiths, us, paid everything in advance. In other words, there was no breach for starters, because there was nothing to breach. We paid in advance, which the lower court agreed with, which is, to me, stunning, that we paid in advance on every part of the contract, and the contract was essentially paid in full if you were to include the promissory note. Everything was actually paid for. So obviously the verdict was stunning to us, but I don't blame the jury. It was a very confusing time, and I think that the instructions could have been better put by us. We could have written better instructions probably, and I think that would have been a big issue. But in my opinion, the bankruptcy issues were tried again, and I think that's just, to me, it's a travesty. And they were found differently, as I've pointed out in my brief. The judge found different. In fact, he went out of his way to directly oppose some of these findings. The term puffery as opposed in a fraudulent context. Judge Liu said this is not puffery, whereas Judge Bailey indicated it is indeed puffery. So it was very odd to find these directly opposing findings in a case that essentially had been tried already. I've done my best to expound on that in these motions. I hope they make some sense. And what to do about it, I know I've put that in there. I know it's not the most elegant request, I think. But I think if the ruling stands, we've got two different histories. We've got one history that occurred in bankruptcy court, which was a valid judicial body, and yet here it is being tried again in another body, and not an appeal. This is a whole new case because the appeal was never timely filed. That's what would have happened. Had there been a timely appeal in the bankruptcy court, these issues could have been hashed over and settled. But instead we had this existing case that carried on through the bankruptcy. Once the stay expired, this went to the Superior Court, and we tried it all over again. And I commend Mr. Reagan for making it happen. We tried the case again, and they've rewritten history to some degree. So that's the crux of it. I know it's very complicated.
So aside from that issue,
Right.
that everything was already decided in the bankruptcy court, and so these should not have been retried, do you have other issues besides? I know that's your primary one.
Right. So I wanted to get through that. I mean, the other one I believe is there was a fraudulent conveyance count that the lower court, I think it was 20 days to prosecute after his ruling. And at that time, we didn't know what the judgment would be, if it would be worthwhile to go after it. And I thought it was, I don't have the case law, I just thought it was very prejudicial to us. This has been going on for 10 years, and he gives us 20 days to pursue it. And he wouldn't hear it in his court. We had put that in his account, but he wouldn't hear the fraudulent conveyance. And it was plain as day. There was a trust drafted during the bankruptcy proceedings that transferred Anketel's sole asset into a trust. He was the beneficiary on it, but out of his name. And even if the dates are off, when the bankruptcy stopped, the lower courts, the case would have immediately sprung into action. So the assets were transferred during a live case, one way or the other, which is, it hits every pillar of the Fraudulent Conveyance Act. I'm not sure if that's the actual name of it, but for us, it's very prejudicial. That was the direction we were going, and we're disappointed that Judge Liu wouldn't hear it. Even more disappointed that he gave us, only 20 days to refile. And again, all I can say is, to me, it was not in the interest of justice. I don't have precedent for it. I couldn't find any, but I just think it was prejudicial to us. And I don't have any questions. So
We definitely understand your argument. We've read the briefs, and
Okay.
we will take it under consideration. Unless you have anything else to add, we will take the case under advisement.
can I think for a little bit? Do I have that form? I don't think I'll take 4
You have
minutes.
15 minutes to do whatever you would like with it.
All right, I'll be quick. I just want to make sure I touch on everything. Thank you. Well, I would like to touch on the 93A award. That was especially personal to us in that, we mentioned the hearing where obviously we don't give that the full weight, but it's relied upon, from my research, it's relied upon very much by courts who decide these cases. They look at the expertise of the OCABR, the hearing officers, whose sole job is to determine these issues. And I can tell appealed the first ruling, lost again, and took it to the appeals court, actually. There's an appeals case, I'm sure maybe you've perused it. He lost again in the appeals case. And the lower court refused to acknowledge any of those findings, very damning findings. They found basically what the bankruptcy court found. Everyone found pretty much the same things. But what especially was egregious to us was when the lower court stated that fixing our house would have been a simple thing. Put a new roof on, airtight, and put an HVAC together in the middle of what the lower court described as one of the worst winters on record in Massachusetts. And to me, that was just ridiculous. If anything deserves triple damages, what else would you need for triple damages in a case like this? Our kids were living in those rooms. It was freezing. And we had very little money because we had to deal with all of this. So it's worked out. We've moved on, but to me, it was just a ruling that was, to get to the point. The hearing officer found that severe. She kept a severe violation, and it's in her report. I know it's not a binding report. I don't know how you would call it. It's not a ruling, but I think it's a very powerful piece of writing, and it was done originally and then on appeal, but it strengthened the fact that Anketel he lost his license, he was fined, and the condition of our house, what it was left in, was talked about again and again, and I found that to be, I know it's not I suppose it's a matter of discretion, if you will, and I found it to be astonishing abuse of discretion to look at that, to hear what we went through, and to have him think it was this double. And I don't know if that's something that can be looked at by you folks. I believe it can be, but among other things, and I've mentioned the other things I saw, I'll go into that as well. I mean, some of the bookkeeping. I look at that. I look at books I look at financial statements, etc. And there are instances where he couldn't read the books, and I saw it. Talked about revenue, gross revenue, etc. And it was compounding. And we've been through this process. We've seen bankruptcy courts, criminal courts through this process, and that was something new to us. That for what it's worth. And I don't want it to look to be a sensationalist, scribe that I put down. It wasn't. It was thoughtful, in our opinion, and and we meant every word of it. But I'll leave a minute. I'll leave you folks a minute. I'll save you a minute. But that's all I've got. If there's any questions.
Thank you for your presentation. Thank you, counsel. The case is submitted.
Thank you.
Thank you, Your Honor.
Calling our next case on the list, docket 23P884. Trites versus Krakonis. If I'm mispronouncing that, counsel, please correct me.
That's correct.
We'll hear first from counsel for the appellant, I believe Attorney Prisby.
Thank you very much to the panel of justices, Edward Prisby for the appellants. I have, I believe, 5 issues to go through in 15 minutes to do it. That leaves me 3 minutes for each issue, so I will jump right in. I am going to go out of order from my brief based on what I think are the most important issues for my client.
Can I just, before you get to any of your issues, the issues that were entered against your client, There was a verdict on nuisance.
That's correct.
There was a verdict on implied covenant.
Yes.
And there was the judge's 93A.
That's correct.
Verdict, right. Negligence was found by the jury, but there's no causation, no damages.
That's correct.
So we don't need to really get into negligence.
That's why I'm doing it out of order.
Okay, good. I was trying to understand from your brief, so go.
I think the negligence is interesting on an academic level, but I'll get to that maybe if I have time at the end. So jumping first right into the good faith and fair dealing argument, as your honors know from reviewing the materials, this is a real estate conveyance where there's a dispute between the builder-owner and the purchasers, the Trites family. The jury awarded damages based on two theories, nuisance and breach of the contractual duty of good faith and fair dealing. Obviously, the contractual duty of good faith and fair dealing arises out of the purchase and sale agreement that the parties entered into. And what was interesting about this is that there were two counts. Breach of the contract itself, which the jury said no, there was no breach of the contract, but a breach of the covenant of good faith and fair dealing. Because at the end of the day, we feel it's unfair that the Trites family ended up with a home with Japanese knotweed in it, with glass in the yard and other debris in the yard. When you examine, though, what the covenant of good faith and fair dealing means is it's not in the colloquial sense, is the outcome fair? That's not really what the courts and the cases are concerned about. What we're wondering is, did the parties treat each other well within the scope of the agreement? And that is...
Doesn't it mean, and I'm sorry for interrupting you, and again, please correct me if my interpretation's incorrect, but doesn't the breach of the covenant of good faith and fair dealing essentially mean that one of the parties was deprived of the bargain for benefits under the contract?
By the opposing party. Right?
Correct.
So one of the parties actually destroyed one of the expected outcomes, or the right to receive the expected outcome under the agreement.
Wasn't an expected outcome in this case arguably Mr. Mateus's client's right to purchase a yard on which he and his family could use the yard without stepping on glass, shards of metal, and without knotweed growing purportedly throughout the yard and possibly doing damage to not only the yard, but the house, the concrete, everything else that they alleged in this case. Why is that not a deprivation within the meaning of that cause of action?
Because that wasn't what the parties' expected bargain was. So the parties entered into an agreement where my client sold them a property as is and made specific disclaimers for the yard, the landscaping, and the weeds, and that's all found in the purchase and sale agreement. So the expectations of the parties when they entered into this agreement was, I'm going to get a new house, you're going to get a yard, and the landscape...
Might not be able to use it.
Well,
you might cut your feet on it, but you got it.
You can use it, but you're taking it as it was. And under the purchase and sale agreement, you have every right to walk the property and say, hold on a second, it looks to me like I'm not going to, the yard that I'm getting here isn't the yard that I want. I want to put a condition into the purchase and sale agreement that you're going to clean this up, that there'll be no Japanese knotweed or whatever. The buyers had the right to do that. They did not do that. In fact, if you look at the purchase and sale agreement, Section 12, which contains the as-is clause, has about 5 or 6 red lines through a middle portion, where the buyers have the opportunity to set the conditions upon which they will accept the property at the closing date. If those conditions aren't met, they get to walk away, they don't lose their deposit, my clients are released. But they didn't set any of those conditions.
Do we expect homeowners to... if you buy as is, I expect you got to get an inspection, you got to check out the HVAC, you got to look at the foundation. Do we really expect homeowners in Massachusetts to do, soil sampling? To go in and dig out the soil and see what kind of plants are embedded in there? That seems, and it was, this whole contract was negotiated. I think there was snow on the ground and maybe hydro seed. So I guess I understand your point about as is, meaning, the buyer has the burden to kind of figure things out, but it's also, it doesn't seem realistic to say you really need to dig into the soil and find out what's going on there.
So let's look at it from the seller's point of view, right? Because we're all either buyers or sellers here in Massachusetts, and chances are you're going to be doing these walkthroughs and inspection during the winter months because you're going to want to buy during the summer months, right? Are we really putting on the sellers the obligation to determine subsurface conditions on their properties? Are we really putting on the sellers to determine what Japanese knotweed is? I've been through this case. I've seen pictures of it. I don't know if it's on my property or not. So the way we do the burden here in Massachusetts is we'll say, okay, this is an arm's length transaction. If we're saying you're going to take the properties as is and you sign on to that, that's your expectation. If you as a buyer are going to say, no, I don't want the property as is, I really want to dig into this, then that obligation is on the buyer to dig into it. Otherwise, what you're going to look at is the cost of housing increasing because now builders, contractors are going to have to determine, okay, what's subsurface here?
I take your point. And this may be more relevant to the 93A issue than implied covenant, but the difference here does seem to be that there is evidence. We have to look at the jury record in the light most favorable to the plaintiff. And there is evidence in the jury record that your client knew about the knotweed in the loam that was used. And the judge also found that there was so much glass and metal debris in the yard that they had to know about it, right? So those are kind of findings that we're kind of stuck with.
Right.
So how does it affect your implied covenant analysis first, that there is a basis to find knowledge of the
So
condition?
the knowledge issue is really interesting. If you get into what was actually said at the trial, Dominic Samina, who was the contractor excavator that my guy hired, testified that he served on the Conservation Commission, and he knew about Japanese knotweed, but only that it was quote-unquote really bad stuff. As far as this testimony of what happened at the property, the really bad stuff was as much as my client knew. Mr. Samina also testified that my client himself Mr. Samina didn't have an understanding that my client knew beyond that it was really bad stuff what it was.
Well, he told your client not to use it, right? He said,
Well,
don't use that big pile of loam.
But he also put it through what what they call that, the sieve, the machine sieve that it sieves out all the remaining material. What nobody knew at that moment about the Japanese knotweed was that was probably a bad idea, because this thing is like a bad comic book villain that if you hit it, it spreads into a million different parts, right? Are we really creating a duty here that for my client to have known under the contract that he should have done something differently beyond what he would normally do to screen out the material instead of spread it around based on the facts and the complaint? I would argue no.
You're contesting the basis for a finding of knowledge, but I guess assume for the moment that there is a sufficient basis for a finding of knowledge. Does that affect your implied covenant position with respect to a known contaminant in the soil? Does that sort of impose on the seller some additional obligation?
It would, because you can't get out from under knowledge of something that would be harmful to a buyer by saying, well, there's an exclusionary clause in there. And I think Massachusetts case law is pretty clear on that. There was an allegation that my client knew, but if you look at what Judge Barry Smith wrote, Judge Barry Smith in the 93A findings said there was no knowledge, there was no intent here. But what is interesting about his finding on 93A, and I guess I'll just get into it now, is that, well, really what Mr. Kirkonis should have done was to make a better effort to remediate this, because this was what Judge Barry Smith found a substantial defect in the property. But here again, what is the contractor's role to remediate Japanese knotweed? Even Mr. Politan, the plaintiff's expert, said, well, this is all really brand new. This is a relatively new phenomenon in Massachusetts that's impacting development. We use chemicals on it, and then we pull it out by the root after several treatments. Or you could go in and you could excavate the entire yard, but there's no industry standard here for remediation. So again, I go back to, what are we telling buyers or sellers across Massachusetts right now? What's your obligation if you know that there's Japanese knotweed on the property? Do you disclose it? Do I need a Japanese knotweed certification form at closing? Do I have to excavate my entire yard? So in that way, this is a really important conversation for buyers and sellers across Massachusetts.
Doesn't that issue really go to the amount of damages that the jury award? I mean, it wasn't a huge damage, what, 180 or 1,000 or something like that?
Yeah, I mean, it's enough. I think it's enough to give somebody pause. And I would say that as far as those damages go, I objected throughout the testimony of Ms. Braze. She was not qualified to render the opinion that she did. She used to be a nurse. Then she was a real estate appraiser for 26 years. Were you to say, okay, there's a diminution of value here for the property, the next step is to say, what's the solution? She said cost secure. Okay, cost secure is, again, excavating this property. You need an excavator. And you need Mr. Paladin to sign off and say, yeah, that was an appropriate cost secure. The appraiser was in no position to say, to give that opinion, candidly. So I do have a problem there. As far as the negligence goes, really...
Before you get to, I want you to get to a little bit more, I want you to get to nuisance, but before you do, are you aware of any cases applying the covenant of good faith and fair dealing to residential real estate purchases or P&S contracts?
No, only insofar as negligent misrepresentation goes. But I hadn't found any with negligence on them. If I go back, all the way back to the original case that I think it's from 24 years ago, where Massachusetts decided to allow for exculpatory clauses to impact negligence, Really, the court's analysis was, where are we placing burden here? If someone makes a negligent misrepresentation through no fault of their own versus someone who makes a fraudulent misrepresentation, the courts have held that the tort is going to be precluded by the exculpatory clause. I didn't find anything with negligence straight up, but just negligent misrepresentation. But I think the same, because it's a tort, I think the same analysis applies, because you're talking about what is the duty.
Okay.
As far as nuisance goes, I think that this is an important distinction to make. So counsel has creatively said, well, in order to get nuisance, a property owner has to create, permit, and maintain a condition on or an activity on his property that substantially or unreasonably interferes with the use of enjoyment of another on their property. Here, rather uniquely, the properties are the same property. So the allegation isn't that my client allowed Japanese knotweed to spread from his own property to the Trites' property after they purchased the property. The allegation is the Trites family bought property with Japanese knotweed on it.
Wasn't there evidence, though, that the Japanese knotweed was in the loam that was on your client's property and spread onto their property, or am I incorrect?
No, there's no direct evidence of that. There's
Is there
circumstantial evidence.
Circumstantial? Okay.
That's correct. But there's also no direct evidence that the Japanese knotweed spread from an adjoining property. If the fact of the matter is my client built a development, lot number 18 or whatever it was before it became 22 Crawford Way, it spread loam that inadvertently contained Japanese knotweed on it before the Trites family owned their property, that's not a nuisance.
Your client owned the property before the plaintiffs bought it.
That's
Is that
correct.
Right. So you were the vendor, they were the vendee.
That's
right?
correct. There were two important cases on this. I apologize. I found these in the lead up to this. One is Wellesley Hills Realty Trust versus Mobil Oil Corp. And the other is One Wheeler Road versus Foxborough Co. And in both of these, I'm sorry. Oh, I'm sorry. I thought I said something. In both of these, what the court said, the law of private nuisance has historically involved conflicts between neighboring contemporaneous land uses. Under Massachusetts law, a private nuisance claim is actionable when a property owner creates, permits, or maintains a condition or activity on his property that causes substantial or unreasonable interference with the use and enjoyment of another. Because the law of private nuisance requires that the interference to be persons outside the land upon which the condition is maintained, a vendee of land does not have a private nuisance action against the vendor for its contamination of the property prior to sale. That was from Wellesley Hills.
Yeah, so there's a line of cases kind of saying that.
Right.
I guess that it seems to help your position with respect to nuisance. There's a suggestion in the plaintiff's brief that, well, maybe the knotweed migrated after the plaintiffs bought it, migrated from another lot. What's your response to
Well,
that?
that could very well be, but number one, you got to prove that. And number two, whose lot was it? There seems to be then that there's a party not involved in this litigation, perhaps a neighbor that owned the lot next door. And
Why isn't that a question for the jury?
well, because I think the jury wasn't, frankly, I think the jury got it wrong. I think you need the neighboring property to be identified. That was never identified at trial. The suggestion at trial was, well, it's a nuisance because this was something that was sort of ongoing on the same property.
Otherwise said, your argument is that any such evidence would be speculative in this case.
Yeah, exactly. Okay. And I think that's it for me.
Thank you very much.
Thank you.
We'll hear from Attorney Mateus.
Thank you, Your Honors. May it please the Court, John Matus for the Trites family, Joseph and Kim.
Sorry, Mr. Matus. You've been before this court before, and I apologize for mispronouncing your name.
Okay, Your Honor.
It's happened to me today once, too, so we're even. There we go.
Unless you're Portuguese, Matias always comes out. I don't know which point the Court would like me to address on this. As this Court knows, I'm usually the appellant, not the appellee. But in this matter, I would just like to point out a few things. First, obviously, the Japanese knotweed appears to be a case of, first time in this state where a jury has found someone liable on this. And nationally, I believe it's only the second. There was another one that I discovered. I thought this was the first. There was one in New York in about 2012 that involved a shopping center. I don't have the quote in front of me, but the shopping center caused Japanese knotweed onto an adjacent property. If the Court wants, I can certainly supply it with that. To the nuisance argument first, since that was the last one opposing counsel was discussing. There are actually three ways that nuisance can come in. First, obviously, as he's pointed out, the argument that this was their property originally, then when they sold it to the Trites, that created the nuisance. The second is that the loam that was spread on all the properties migrated over to this property.
What was the evidence of that at trial that gets you beyond speculation?
Okay, beyond speculation, Your Honor, is the fact that both the contractor, the excavator, and Mr. Krakonis stated that the loam that from that pile that the excavator saw that was filled with Japanese knotweed, 5 or 6 feet high, I believe the excavator said, he sifted that, and that was put into all of the other soil, and that was spread across the entire property evenly. There was no question that, I quizzed them. I said, do you remember if the loam was put on X property or Y property, specifically the Trites? And he said, well, you know, it was all mixed together. Both of them kept insisting it was all mixed together.
Was there evidence where the pile was located?
Where the pile, initially, it was down the street on the defendant's, when the excavator appeared, obviously there were no houses. This was virgin land. The pile of knotweed that he could see was down the street, not on the Trites property where it was going to be. But he saw that it was a pile of loam, and he saw that Mr. Krakonis was going to use that, and he saw the Japanese knotweed. And Mr. Krakonis advised him, after he told him, don't use it, put it in, and that was spread across all the properties, including the Trites.
And so that's the excavation process, and the knotweed contaminated loam is spread out on the property, and then your clients buy the property, right? So this does seem to run in headlong into the principle that your brother raised about a vendee of land does not have a private nuisance action against a vendor for contamination of the property prior to the sale.
Well, in this case, it's a deliberate contamination. I know he used the phrase inadvertent, but the evidence definitely showed that the developer knew it was full of it, and he deliberately spread it.
Yeah, but the knowledge is like a side issue, though, right? I mean, it's sort of the nuisance has to migrate from one property to another. That's the general notion of nuisance, right? And there's really no evidence that the knotweed migrated in the record. I guess it's possible it could have, but there's no evidence. And certainly the glass and metal debris didn't migrate.
Well,
right?
no, that didn't migrate.
That was there to stay, right?
Well, as expert Chris Politan pointed out, this stuff spreads, it has a will of fire, it spreads incredibly easily. So if it is on your neighbor's property, the knotweed, excuse me, not the glass. So when it is on your neighbor's property, unless they're severely taking issue with keeping it and getting rid of it, it's, and I have other cases that probably will appear before this court where it's spreading just as a natural course. You expect it. It doesn't obey property lines. So I have it over here, and here's the property line. Unless you're an expert like Chris Politan and you're able to keep it in check through digging trenches around it, it's assumed it's going to spread. It can spread underground even if you're not looking at it. So the jury had that evidence in front of them when Chris Politan testified that it spreads so easily and rapidly.
Yeah,
that
but evidence that something can spread is not evidence that it did spread.
Well, the jury certainly found, the jury's verdict suggests that they did find that it did spread. And the jury's verdict was...
I think the jury would didn't apply the principle that you can't. And anyway, your nuisance claim may have some vulnerabilities, but can you address the implied covenant and the 93A, which are alternative basis for the same relief you got below?
Yes. The implied covenant of good faith and fair dealing, it affects what is the expected outcome. There are three major ones that pop up first. First is that when you buy a house with a yard, that you're going to be able to use the yard unless you're specifically informed, well, you can't use the yard. And it was part of the deal. The second is that the house itself is not being threatened by whatever's on the yard. That's an implied thing. It's not, and the Japanese knotweed specifically threatens the house. As Chris Politan testified, and as Bonnie Bracey also testified, this stuff can crack a foundation, crack infrastructure, crack a driveway, and this is not something you bargain for. You expect a house that has defects free, especially in this case where it was a brand new house in virgin land. There might be some kind of argument, and I'm just speculating here, that coming to a used house that's been there for many years, perhaps a developer may be able to skirt liability on that if it's already there. But this was a case where you're buying something brand new, and I made this point to the jury. You buy a brand new product, you pay a premium, but part of the reason you pay that premium is you're expecting defects to be non-existent. There's no wear and tear on the property.
Can I ask, the biggest problem I see with your implied covenant position is that the principle that the covenant pertains to bad faith in the performance of the contract, not in its execution. And so an undisclosed matter seems to go to the execution of the contract, not how the terms of the contract are carried forward by the parties. What's your response to that?
Well, it's a difficult question. I will add there's one other good faith and fair dealing here that I'd just like to point out, and that is you're buying a house not expecting that you're going to have to be worried about something that could potentially cause you liability to your neighbors. Because there is the argument that once you know there's Japanese knotweed on your property, you don't do anything about it, and it spreads to your neighbors. Now your neighbor, as opposing counsel has brought up, might potentially be, there might be a neighbor versus neighbor problem even if somebody else put it on your property. So those are the three things, the implied covenant fair dealing. But caveat emptor is not the law. It's not the law in this sort of thing. It's definitely something.
But aren't people buying houses all the time now in a caveat emptor sort of way? People are purchasing houses not only with as-is clauses in the contract, but buying it without an inspection. That's not uncommon today at all.
Well, I do not know. I don't know.
So, for example, people buy a house and they say, we're going to take it as is, no inspection. Turns out the house has asbestos. And I believe their case is saying, should have gotten an inspection. Why is this different?
Well, this is different because they had an inspection. They did everything according to the law. There's no question here that there was something that they were supposed to do, like normally, like get a home inspection, and they didn't do that, and something the home inspector would have discovered was there. The home inspector himself testified in this case, and he stated it is not normal course or Massachusetts law that a home inspector check the yard or does a soil sample or looks for Japanese knotweed. So no matter how many of the, if they followed every single law to the letter, the inspection would not have reduced this. And we say that they followed the law to the letter. We're not implying that they didn't do anything. So in the cases where, I can't speak to those cases because that doesn't apply here. The inspector came, he gave his results, he said, well, we don't look for that in the yard. Plus, their ability to inspect the lawn was impaired in this situation because of the timing. First, you had the fact that when they first got there, the entire, the neighborhood, there was lots of houses being built. Some of them were still being built. Theirs was completed at the time, but their yard was not, I shouldn't say it wasn't complete because they proposed it was complete, but first there was snow on the ground, so they couldn't walk the lawn at first. Then the hydro seed.
And there was hydro, yeah, we're aware of the facts. I don't want you to spend your time on that.
So they can't walk the lawn at that point. So they can't see the defects. There might be an argument that had this been the middle of the summer and there was no problem with walking the lawn and their kids went out, they didn't check it. But in this situation, they were inhibited from doing that. And if they, they assumed that this person, the developers, were acting in good faith and were going to give them, they were checking out the house and, there were, the inspector made his notes and they had, but they assumed, well, the yard's going to be fine because, well, he's representing it as fine. And this is
I have one more question on the same question I asked Attorney Prisby, which is, are you aware of any cases applying the covenant of good faith and fair dealing in Massachusetts in the residential purchase context?
No, I'm not, Your Honor.
Thank you.
Can we talk about 93A?
93.
It seems like there is authority under 93A where the non-disclosure of a material fact can provide the basis for a violation. I want you to talk about, is that a fit for what happened here?
Yes, Your Honor, especially since beyond the Japanese knotweed, the junk in the yard, just to be blunt about it, was something that was just not disclosed. I mean, even if the jury had credited all of his arguments that he just didn't know what Japanese knotweed was, didn't know it was a bad thing, the volume that the jury saw, and the judge noted that in his 93A, I'm just pulling it up, and also the dangerousness of this. The glass that cuts your feet, they can't use the yard, they testified to that fact, the rusty car parts. These were so egregious, I believe the judge used the term egregious. He listed 6 major reasons why he was granting the failure to disclose both the Japanese knotweed and the metal and glass, the selling of the property with these defects, which posed health and safety risks. And like Japanese knotweed, we'll say, it's not dangerous to humans, and it's not dangerous to pets, as far as we know, but it is dangerous to infrastructure. But the metal and glass certainly was dangerous to the dogs and the people.
If you can just expound on that point a little bit more, because I think knowledge, for this theory, knowledge of the condition is critical to liability, and seems to be the excavator's testimony provided knowledge that the defendant was aware of the knotweed issue. But is just the sheer quantity or amount of glass and debris in the yard enough to establish the defendant's knowledge? And if so, why wasn't that detected? If it's really that conspicuous, even if there's snow on the ground, you would think someone buying a property might pick up on there being a lot of glass and metal debris in the yard. I don't that's the difference.
And the testimony and the transcript that when I asked the Trites family on the stand about that, and also other witnesses, there were friends of the family who testified because they had been over and witnessed this, there was a slight layer of topsoil after the hydro seed had been lifted when they first moved in, and of course moving in they were more concerned about getting their stuff inside the house at the time. It was only after about a month where erosion happened and just general use of the lawn, where all of a sudden that covering, that little cake frosting on the lawn, went away, and all of a sudden all this dangerous glass was now visible. At first they couldn't see it, and then after about a month, it only took about a month roughly. I think they said that they closed around Memorial Day, and it was the middle of June when they started to notice the debris and the Japanese knotweed at the same time. And again, as there was, that this stuff was not obvious at first merely because of this layer of topsoil. I mean, you can't walk, if it's covered by a foot of snow, you might not notice, you're not going to notice that underneath. Also, I'll point out a few things. First, that the balance of knowledge in this kind of situation is heavily in favor of the developers. This is they're not buying this for profit, they're not buying this as business, this is their family home, they wanted this to be their forever home. There was testimony from the Trites that the whole reason they bought this, there was two major reasons. Number one is brand new, hoping for no defects because Mr. Trites, who largely takes on the maintenance in the home, he works, he's the sole breadwinner, so he is working. The second reason is they were priced out of their prospective hometowns of Woburn and Burlington, housing prices being what they were. And so this was a situation, they were not buying this to flip. They were buying this to live in it. Whereas the developer, he's got 30 years of experience, he testified to that. This is one of a number of projects he's worked on. The balance of knowledge about what is important and what is heavily in his favor, and I believe that should be looked at, it should be looked negatively against him on that.
You've got a minute left. Would you mind speaking quickly as to the damages issue?
The damages issue. Well, Ms. Bracey, she testified to a damages amount, which the jury clearly found credible. She testified that she relied on four things when she came to that. First, she did her own appraisals, five things. She did two appraisals. Number two, she spoke to the Trites family. Number three, she spoke to Chris Politan, the expert. Number four, she did her own research, and she does use the phrase, I did my own research. And number five, she used her experience of 20 years of being an appraiser, doing 2,000 appraisers. Sorry, I wrote 20,000. I'm not good at math. It's only 2,000 according to her estimates. She gave that, and then after saying, I used those 5 data points, she gave her amount. Now, and the judge stated to opposing counsel, you'll be allowed to cross-examine her about it. He never cross-examined her. He did cross-examine her, but he didn't cross-examine her on what research she did. She said, I did research. He never said, what kind of research did you do? Explain your research. The jury clearly found her credible. Now, that could have been a tactical decision by opposing counsel, but the fact that they did not ask her to explain her research and perhaps poke holes into that testimony she wanted is not the fault of the Trites family. She stated, that's my research. And the jury was free to believe or disbelieve her. They clearly found her credible. And
your time has expired, but you can finish your answer. Go ahead.
So, Your Honors, she laid a basis for it, and the defense counsel attempted to poke a hole in it, but they did not ask her about her research, which she stated was a basis for it.
Thank you both. I'll state for the record, both parties have been very well represented on this case, and the case is submitted. Thank you.
Thank you, Your Honor.
Good to go. Excellent. Next case, docket 24P245133, West Main Street Realty LLC versus Kimball. Good morning, Attorney Breyer.
Good morning, Your Honors, and may it please the Court, I'm Michael Breyer, representing the appellant in this case, 133 West Main Street Realty. The principal question of this case is whether a landlord acts in trade or commerce for the purposes of 93A under the facts where it initially charged no rent to the tenants, then it charged below market rent, never earned a profit from the rental, never intended to earn a profit, and owns no other rental properties. It's our position that 93A does not apply because...
Does he own no other rental properties?
So the owner of the case, the owner of record is 133 West Main Street Realty, which owns no other properties.
Right, but there's evidence in the record, if I'm not mistaken, and please correct me if I'm wrong, that the CFO of Mr. Mayer's company helped him manage rental properties that he owned, and I believe that he owned various properties and rents out other properties under the name of other LLCs or in his own name. Is that correct?
That's correct, Your Honor.
Does that include residential rental properties?
I believe Mr. Babigan's testimony was that it was a mix of residential.
Residential and commercial.
Yes. The case law, there's a number of cases interpreting whether landlord-tenant relationships implicate 93A or not. One of the cases that I cited in my brief is Billings versus Wilson, where the SJC determined that rental of a residential unit in a two-family home where the landlord owned no other property did not implicate 93A.
So does it matter here that the landlord, not necessarily the entity, but the landlord himself owns various other properties which are managed by himself and the CFO or what have you?
I would argue not, Your Honor, because the owner of record is the LLC, not the manager. And obviously, the manager and the LLC are different legal personalities. But in any event, even putting aside that issue of...
It's a factor we're supposed to consider among the many that are listed in the Sullivan case and the other cases you cite.
Right. In any event, as I note in, relying on the Wittinsky case, the central question is whether the arrangement between the parties had an entrepreneurial, commercial, or business purpose for financial benefit or gain. And here, the undisputed facts establish that originally Mr. Kimball was going through a divorce. Mr. Mayer was his boss. He owned the property at the time, was his boss, and gave him a place to live for 4 years, rent-free. Eventually, Mrs. Kimball moved in when they got married and charged him no rent for all that period of time. And then, during the years that followed, charged him below market rent. In fact, the only evidence in the case regarding what fair market rent was, besides the actual amount of rent charged itself, came from Mr. Babigan, who testified that the fair market rent of the property was well above what they were charging. It's also undisputed that the LLC itself never turned a profit from this property. There's evidence in the record regarding real estate taxes, insurance, all of that. And based on all of those factors, I'd suggest that the evidence clearly points to the conclusion that the arrangement was simply not the sort of arrangement that implicates 93A.
What kind of arrangement was it? If I have one of my employees, if I put them up at one of my rental properties, that's almost a form of compensation, isn't it? Or it's at least an inducement for the employee to stay with my business. How do you disentangle sort of the employment relationship aspect with this? It's not just a mere personal friendship. this person's working for, Mr. Mayor.
That is true. I mean, he worked for one of Mr. Mayor's other companies, so there is this difference of entities. But I don't think there was any evidence in the record about this being an inducement to continued employment, or this being some kind of arm's length or not so arm's length, as the case may be, negotiation between the parties. Hey, I'll take a low salary or a low hourly wage, but in return I'll get free housing or below market housing. So I think that the answer simply is not answered by the record.
But the landlord had a benefit. The payments were made through paycheck.
Right. So the money was direct for the rent was directly withdrawn from his paycheck.
But that's a substantial benefit to the landlord. Wouldn't you agree? There's a certainty of getting that money, which is not the case from other people who may rent.
I suppose that is a benefit. I'm not sure if I'd agree with Your Honor that it's a substantial benefit, but it certainly is a benefit.
You would agree that this analysis, trade or commerce, is a mixed question of fact and law, right? Because the case law says to look at all these different factors, which we have to evaluate, and then we have to see whether or not the judge's calculus, fits within the case law.
Yes, I mean, that's right. Obviously, in this case, the judge simply made the finding that they're within trade or commerce. There's no subsidiary findings whatsoever to support that conclusion. My position is, and there is a wealth of cases that I cite and many, many more that I don't cite, where the appellate courts decide that what sort of conduct falls within the ambit of 93A is a question of law. There are some cases where there's disputed facts or something of the like where it becomes a question of fact. But I think despite the fact that there are all these factors, there are many cases where it's decided as a legal question.
A lot of the authority you cite, or most of the authority, is owner-occupied properties, right? And so
That's right.
A family who has a house and has an extra unit, they rent out that unit. Is there any case where an LLC owns the house and that seems to just goes, the very concept of a limited liability company seems to go against the underlying principle of an owner-occupied exception to trade.
In my reply brief, I cite the Hebrew Senior Life versus Novak case, which involves subsidized, it's an appellate division case, so it's not controlling authority, but it's persuasive authority, where basically Hebrew Senior Life, there was a subsidized lease, there wasn't intent to earn a profit, and yet the appellate division determined as a matter of law, not as a matter of holding a factual determination, that wasn't enough to implicate 93A. So there you have, granted it's not an LLC, it's another type of entity, but I do rely on that.
Thank you for including a copy of that, by the way, with your reply brief. I have a question for you on the nominal damages issue. Is it clear that the damages under 93A in this case were for a violation of 940 CMR 3.17?
It's clear, yes, that's clear to me.
Is there any precedent for actual damages being a possible remedy for violation of that requirement?
So the Ponce case is really the seminal case, and I cited it in my brief. And
Ponce case says no, but my question for you is there a case that says yes?
I did not find any case in my research where there was an award of actual damages. Ponce does, in candor to the court, leave open the possibility that it could be proven on some hypothetical set of facts. But it says basically what I understand the Ponce case to say is, generally speaking, the fair market rent, it's reasonable to infer fair market rent is going to be the actual rent plus the utilities. So therefore, the fair market rent is exceeding the actual rent, and really the award of damages should be nominal damages, unless you can actually prove actual damages. And here I'd submit to the court that if the court determines that there was sufficient basis for the trial court to make a 93A trade or commerce finding that really nominal damages is the correct remedy. And again, the trial court did not explain its damages award in a lot of detail. It did cite Exhibit 12 of the trial record, which are the water bills. But again, there's just no evidence from which certainly the trial court did not make a finding. And I'd suggest to this court it could not have permissively made a finding that any of the various possibilities outlined in Ponce where there could be actual damages was proven. There certainly is no evidence that the fair market value of the property exceeded the actual value, plus the electric bills. And also, my brother makes these points about, well, there was evidence about electrical problems, about heating problems when they moved in, which seems to me outside of the statute of limitations. But in any event, the trial court explicitly found no breach of the covenant of quiet enjoyment. And, all of the various bases for breach of the warranty of implied warranty of habitability were advanced by my brother, and the trial court rejected all of them except for the lead paint. And for lead paint, it awarded damages, and we don't challenge that finding. Not as clearly erroneous. So I know I only have a few minutes left, so just to move on, there is this issue of multiple damages. Again, it only really comes up if you reject my other arguments, but this court has said that really callous and intentional violations of 93A are when you get multiple damages. Here, there was no finding of callous or intentional conduct against my client. The evidence, I think, was uncontested that he simply didn't know about this regulation, which may be negligence, but it's not willful or knowing for the purposes of 93A. My brother relies on Montana's versus Bagg, but I think that case is distinguishable because it was a case where the landlord knew that the property had no heat, it was uninhabitable. Very different than.
Was there evidence in this case that when Alan moved in, that there wasn't functioning heat or functioning electricity? I'm trying to understand. What does the record show about what utilities weren't working at the time he moved in?
There was some evidence in the trial, as I recall, maybe a year later, about there being an interruption in electricity and some issues with the freezer. And then there was an allegation about lack of heat and or inefficient or insufficient heat where they needed to use heaters when they moved in. But I would suggest to the court, first of all, there was no finding by the court that there was any breach. And obviously, I did raise statute of limitations as a defense, and it's 4-year statute of limitations for 93A. And then the last point I would just make is that under 239 Section 8A, I don't contest that the Kimballs were entitled to avail themselves of the protections of that statute. But where I do take issue with the trial court's rulings is that the statute explicitly says you're supposed to award interest on the unpaid rent. And the trial court did not do that. I asked the trial court to do that in my motion to alter the findings. The trial court did explicitly find that the last rental payments had been made on February 5th, 2022, so we have a date of breach for the purposes of the interest statute when interest should have run. And so I'd suggest to this court that interest should have been awarded under the plain language of 239 Section 8A. So with that, I'll just answer any further questions that the panel may have.
Seeing nothing further?
I'll rest
Thank you
on
very
my
much.
brief then, Your Honor.
Appreciate your argument. And Attorney Barnes?
Yes, good morning, Your Honors. Let me address that first point, and that is the trade and commerce. I think the case law and the facts in this case are pretty clear. This was not an owner-occupied home. It was not a home that the landlord ever occupied. And under 93A, Section 1, it specifically says that it's trade or commerce when the owner of the property rents out or leases property. That's exactly what you had here. Now, my brother cites in his briefs, as you guys noted, that owner-occupied cases where it's a landlord's own home being rented out. We don't have that. Clearly, we don't have that here. And I'd ask you to pay attention to the cases that I actually did cite, which was the Continental Insurance case. And I think they summed it up nicely, which they said, I quote, "That ends the matter is used in Chapter 93A. Trade or commerce specifically includes the sale, rent, or lease of property." And in that particular case, they referred to a gentleman named Bannon who rented out his entire property, not owner-occupied property, but the entire house. And that court said, you apply that fact to 93A as it's defined, this is trade or commerce.
Right, but it's a federal case. We're not bound by that. So the question becomes, what's your best Massachusetts authority?
That's true, but they refer back to the Linthicum case, which is the base case in this court, as you know, in the state, on the issue of whether it's trade or commerce in the renting of property. And they cite that and they rely on that. So I'd ask the court to uphold the judge's decision on that finding. I want to now touch on the willful knowing issue that my brother...
Before you get there, I'd like to ask you about the nominal damages issue. So you agree with your brother, I assume, that the damages for the 93A claim stem solely for the violation of 940 CMR 3.1711, correct?
Correct.
Is there any precedent for actual damages being applied for a violation of that regulation?
I have not seen any case law, but the Pons case, as my brother noted, and I cite in my brief, has at least 3 exceptions where they specifically say that the situations could arise. And I would say that that's what the court recognized. Although I will say the judge in the housing court didn't specifically say which exception he was falling under, but the Pons court specifically said that multiple damages might have been recoverable had the tenant proved an arrangement actually had a negative impact on their use and enjoyment of the property. And there was sufficient evidence of that as well.
But isn't that contradicted by the unfavorable verdict you received on the quiet enjoyment claim?
I would say it could be, but here's the second part to it. The other exception that the Pons court says is damages might have been recoverable if the rent and the cost of utilities together were more than the fair rental value of the property. And that, I believe, the evidence showed that because you saw evidence of the $9,470 that my clients paid in the water and sewer bills. The rent itself was approximately $1,231 a month.
But what was the evidence that that was the fair rental value of the place? It seems to me there was evidence that the landlord was doing the tenant a favor and was renting it well below market value. So where's the evidence that...
I would say the evidence is from the judge's finding of what the rental value was. He made no findings accepting any of my brother's testimony as to what they believed the fair market value was. The judge actually, when he awarded the breach of warranty of habitability claim, found it based on the $280 a week, which I would say that would mean that the court...
Did the judge make an actual finding that that was the fair rental value of the property?
No, I did not see that in his decision. So I would say, Your Honor, that in terms of this particular situation, we fall under at least 2 exceptions in the Pons case. Although the court did not make any specific findings, you can infer from the judge's decision that he found it. Now, I would also like to address the willful knowing aspect of this. As I raised in my brief, Your Honor, first and foremost, I believe my brother waived that argument. And I cite that, the case, the R.W. Granger case, where it was not brought up prior to the decision. It was not brought up in closing arguments. It was brought up for the first time when my brother sought to file amended findings of fact, which the judge denied by that. So from a legal point of view, I believe that the landlords waived that argument. But even if they did, you consider the fact that he didn't waive it. You can look at the case that I cite where this court can infer from the judge's decision that he found willfulness or knowing from the simple fact that he doubled the damages. And the case that I cite there is the service publications case. And that's exactly what we have here.
So what's the evidence in the record regarding the willful or knowing nature of the violation?
I believe that he, again, from the judge's decision-making, I believe he inferred the willful knowing from the fact that this was a experienced landlord. I know there's been discussion about whether the manager or the LLC owned anything else. In this case, Mr. Mayor, who was the manager, owned several other properties, as you guys noted before. In this particular case, the violation of the fact that he had his tenants paying the water, the sewer, knowing that that's not something that normally happens. That's what I would say the judge inferred when he made that decision to double the damages. And that's what is allowed in the service publications case. The court specifically said that we may infer that the trial judge made a determination of willful knowing because the judge awarded the double damages. In that service case, they didn't say, we didn't see any finding from the judge, but they inferred that the judge found it, the fact that he doubled the damages. And that's what I would ask this court to do, is to recognize that the judge did infer that. And then the last part that I want to address, Your Honors, is the 239 Section 8A interest. The way the statute's set up, and I did not find any case law, and I don't think my brother did either on this, but the way the statute's set up, it's actually kind of considered as prejudgment interest, which there hasn't been when that decision was made, there hadn't been an actual judgment set. Whereas, as you can see from the judge's decision, if my clients didn't pay the offset, then the interest was going to be added to the landlord's judgment.
But what does it mean in Section 8A where it says there shall be no recovery of possession if the tenant, within 1 week after having received written notice from the court of the balance due, here's the important part, pays to the clerk the balance due the landlord together with interest. What does that language mean?
And that's what I'm getting at. There's no case law that defines what type of interest we're talking about here, but it has to be considered prejudgment interest. And there isn't a judgment yet when they do that. That's where I say there's no case law on that to really define what's being discussed there. I understand what the statute says.
But isn't the point that payments haven't been made over a period of time, so therefore you are obligated, if you want to recover possession or maintain possession, to pay interest on what was owed and wasn't paid?
Again, I don't disagree with that.
I'm just trying to go by the plain language of the statute before we get to case law.
Sure. No, I understand that. And that's the difficulty, I think, in applying that particular statute. There is no case law that I've seen, and again, my brother hasn't. But even if there was interest to be added, it's when does it start? And as I cite in my brief, it doesn't start till the complaint was actually served, which was in June. It's not back in February, my brother argues, where the rent wasn't paid.
What's your justification for that argument?
Because when you have judgment on a interest on a judgment, it starts from when the suit is filed. And in landlord-tenant cases, as I say, a suit doesn't commence until it's actually served on the landlord, by the landlord on the tenant.
But the balance due the landlord together with interest, the balance due goes back a lot farther in time than when the suit was filed.
Again, it goes back to, are we talking prejudgment interest?
No, I
And I
understand.
don't, there isn't any case law on
An
it.
interesting issue, thank you.
There isn't anything else. I would just ask, I was asked the court to affirm the lower court's judgment, and I would actually ask, as I requested in there, for costs under Section 26 and for attorney's fees under 93A. Thank you.
Well argued by both parties. Thank you very much. The case is submitted. Calling our next case on the list, docket 23P 1297, D. Simone versus Tarasuk.
You're violating my due process. If that's the way you want to go, you're violating my due process. Do I have this here? Justices?
Excuse me, sir, you are welcome to sit down, please, if you'd like to observe the proceedings.
That's no problem. There's pending orders. We'll see. I can leave that. You gonna let me speak? No. Then you ruin the due process. That's fine. Go ahead. Violate my rights.
Okay. This is docket, for the record, 23P 1297. We've received a brief from the appellant, and the appellant will be allowed to argue. Is it Attorney Herbert?
Good morning,
Go ahead,
Your Honors.
sir.
May it please the court, Christopher Herbert on behalf of the tenants Ryan Tarasuic and Joanne Bernard. The housing court unfairly surprised these pro se tenants on the morning of trial when it told them that what had been proceeding as a non-payment case would be tried as a fault case. As a result of that decision, the housing court also ruled that Section 8A would preclude the tenants from raising their affirmative defenses and counterclaims based on retaliation and the conditions of the premises. Because that later legal error is wrong, regardless of whether the housing court abuses discretion in changing the nature of this case in the morning of trial, I'd like to focus in on that issue.
One preliminary question. Have the tenants vacated, or are they still there?
Tenants are still there, Your Honor. Starting with retaliation, that is a viable defense and counterclaim in all types of summary process actions, not just those brought for non-payment of rent or without fault of the tenant. The plain text of the retaliation statutes, Chapter 239, Section 2A, and Chapter 186, Section 18, do not limit those defenses and counterclaims to non-payment cases or without fault cases. They apply to, quote, an action for summary process, meaning an action for summary process, and, quote, to any tenant of residential premises against whom reprisals are taken. That does not limit it by its terms to non-payment and without fault cases. That's important because the legislature knows how to target particular types of summary process actions. All throughout Chapter 239, the legislature has specified specific types of summary process actions when it wants to do so explicitly. In Section 18 itself, in Chapter 186, the presumption of retaliation applies to, quote, any notice of termination, quote, except for cases of non-payment of rent. That similar type of language does not exist in the retaliation provision, the presumption provision in Section 2A. So the legislature's making conscious choices here about when it chooses to target particular types of summary process action and when it doesn't. In Section 2A and 186, it has not. Those similar types of targeting exist throughout 239. In Section 3, it talks about satisfactions of money judgment in, quote, any summary process action for non-payment of rent. Section 9 talks about summary process action brought, quote, without fault of the tenant except for notice of quit by non-payment of rent. And Section 15 similarly targets the effect of emergency rental assistance and payments for cases for non-payment of rent. The case law also tends to support that retaliation is available as a defense and counterclaim in for-fault cases. You know, it's true that there is not a particular case directly on point that answers this question. However, it seems that courts have kind of just assumed that, of course, retaliation is available in for-fault actions. think South Boston elderly residents versus Moynihan is the best case on this issue. Justice Milkey of this court reversed a finding of no retaliation in a for-fault case based on the landlord failing to overcome the statutory presumption that's given.
You said Justice Milkey found. Are you referring to a single justice case, or are you referring to a...
This is a published decision by Justice Milkey that he authored. Yes, I apologize, Your Honor.
What is that decision?
That's South Boston elderly residents versus Moynihan. It is cited in our brief, Your Honors. The site is 91 Mass Ave Court, 455. The facts of that case are there were complaints by the tenant about mold and water issues. There was some attempts at remediation early on in the process. Eventually, the landlord came to the tenant and said, hey, your apartment is a mess. We can't really come in and do this type of work. And also that is a violation of your lease. Then they kind of let matters lie dormant for a while. Tenant brought up the issue again and eventually reported it as a violation of the state sanitary code. And then soon after that report, the landlord was contacted and then sent a for-fault notice to quit based on the state of the apartment and the clutter in the apartment. Justice Milkey said the case was tried, retaliation, defense, and counterclaim were available. The lower court found that you, landlord, overcame the presumption of retaliation, and then eventually Justice Milkey said, no, you had not done so. So there is no express ruling in that case that says, of course, Section 2A and Section 18 apply in for-fault cases, but it was tried that way, and the presumption was applied, so they obviously applied it there.
Can I ask a preliminary question? The judge, the second notice to quit states both non-payment of rent and a pet violation. And the parties go in with the expectation that both of those issues are going to be covered, and the judge said, no, you can just do one, and we're just going to do the pet violation. What's your position on that? Was that error? Did that prejudice your clients? Is there a rule that says only one cause can be tried at a time? I'm just trying to understand what your position is with respect to that initial determination, the initial decision to supposedly cabin the trial to the pet violation.
Yeah, so, if we're talking about what notice to quit was effective, whether it was the initial January 3rd or the later February 3rd, where the first was just on non-payment of rent, and the second listed non-payment and the pet violation, I don't think we have a particular view as a legal matter, whether the second overrode the first and they had to go forward on the second. And I don't even think we have a particular view about whether it was, an error of law to say, you have to go forward on the non-payment you have to go forward on the for-cause pet violation versus the non-payment. What I think really happened there is that, if you read the record, it kind of seems like the judge just missed the fact that the second notice to quit also said non-payment. And he only brought up the fact that when he was looking at it, he only brought up the pet violation. We have a cold record here. It's really hard to tell kind of what actually happened. But where I think the error comes in is if you look back to how this case was tried kind of from the beginning, and you look at the pretrial conferences where the parties are talking about, yes, this is going to be a non-payment case, of course counterclaims and defenses are going to be available, and everybody kind of proceeds that way.
Stop for 1 second,
Yes.
counsel. Just wait a second.
You're all in trouble, back in the council, let's start praying.
You may continue.
Thank you, Your Honor. So if you look at it, you show up on the day of trial after having these two pretrial conferences where the parties are discussing non-payment. Even when the judge starts talking about it on the morning of trial, you have the landlord's counsel saying, no, we're going to be non-payment judge, non-payment judge, non-payment judge. Everybody's there thinking they're going to try a non-payment case, and then the morning of trial, the judge changes it to a for-fault case based on the pet violation. Unfortunately, this case is not cited in our brief, but I do want to call it to your attention. It's Cambridge Realty versus Stewart. The site I have here is 481 Mass 121, where the court did say, the SJC did say it was an abuse of discretion for the judge to, a slightly different factual scenario, but I think
What year is that case?
Yes, Your Honor. It is 2018.
It can't be 41 Mass then.
481 Mass.
481, thank you.
I apologize.
It's probably my hearing, not your voice. That's fine.
I'll try to project a little bit more.
It was abuse of discretion to...
It was an abuse of discretion. So what happened was there was a default judgment entered against the tenant. She cleared the default, went to court and said, tried to get the default judgment overturned, and she did. Then the court proceeded with trial that very day without giving her notice beforehand that the case was going to be tried. So it is a little bit of a different scenario where you show up for court for one reason and then are told you have to go to trial, but I think the effect is the same. You're told that you're going to trial to talk about one type of case, non-payment, and then that morning you're told, never mind, you're going to be doing this other type of case that nobody has been focused on so far.
All right, so it doesn't seem like you have a clear position on just, it seemed like it was unfair, unexpected, but the decision just to cabin the trial to a pet violation, let's assume that was a valid decision. To what extent did the judge err by then subsequently allowing testimony about the non-payment of rent come in?
So I don't think it was an error, if we're cabining this to a for-cause case on the pet violation. I don't think it was error to allow testimony about the unpaid rent to come in, because in a for-cause, for-fault case, you can still seek damages for unpaid rent. That's a different it's a different type of action than seeking summary process eviction for non-payment, right? You can come in and say, I want to evict you because you're violating the lease, because you have a pet when you're not supposed to, and also you haven't been paying me rent, and you can seek damages in that way. You can't get possession on that basis if you bring it under for-fault, or you can seek damages for rent. At least that's what the judge ruled.
So your position is you can have a for-cause trial, bring in evidence of non-payment of rent, and thereby exclude defenses that would otherwise, or counterclaims that would otherwise be available to a non-payment cause.
So
is that acceptable in your view? Is that
so
your understanding?
it's not acceptable to exclude the defenses, and that's another point that I wanted to raise. So the condition-based defenses here that the judge disallowed are always allowed to defeat claims for rent. Right, the judge disallowed them on the basis of Section 8A, which says, in his view, says you can't bring any type of defenses and counterclaims in for-cause cases. That may be true to a certain extent, but the conditions-based defenses aren't governed solely by 8A. You have cases like Rosa and Hemingway that say whenever there is a claim for unpaid rent, whether it's possession-based or just seeking damages, the tenant can raise as a, quote, complete or partial, as a total or partial defense to the landlord's claim for rent. That's Hemingway. And that's even if 8A doesn't apply because, for example, you haven't followed the notice procedures, or as the judge said here, you can't raise defenses under 8A.
Okay, just make sure I understand.
Yes.
Your position is if the trial is limited to the cause of the pet violations, but non-payment of rent is a subsidiary issue or a claim for damages, then there should be no restrictions on defenses or counterclaims that would otherwise be available if it were just a non-payment of rent action. Is that your position?
Yes, I think that is our position, with the caveat that, the defenses and counterclaims that you have with respect to the rent are really in natures of damages and abatement. It can't defeat a claim to possession. So that's different than what we have in Section 2, retaliation, where that should be available in all types of summary process cases as a defense to possession. As a defense to retain possession, whereas the conditions-based defenses under, the implied warranty of habitability to defeat the claim for rent are just trying to defeat the claim for rent. They're not also then going to be subject to the 8A procedures of balancing to figure out who maintains possession. I do want to circle back to the retaliation issue for just a second, because I think it's important to think about what the opposite ruling that we're seeking here would allow. In this situation, we had an instance where the landlord was aware of the dog for quite some time. You can see from the record that the text exchanges at trial that were entered were from February and June of 2021. The notice of the violation didn't come until November of 2021, the day after the landlord had TRO entered against him, after the tenants filed an action, and then he asserted a for-cause reason of the pet violation. If 2A and 18 do not apply in for-fault cases, what that's going to allow is exactly what happened here. Pocketing prior violations of which the landlords were long aware, and then allowing them to overcome the statutory presumptions in 18 and 2A based on a ruling that those don't apply to for-fault cases. We don't really want that to happen, as SGC has noted. 2A really reflects a desire to protect tenants who report violations of the housing laws, and any other ruling would eviscerate the presumptions available in those statutes that seek to do just that, is to protect tenants who report violations of the housing laws. And without, if there are no further questions, I would rest in the, actually there is one. We did raise the notice issues, the equivocal natures of the notice of quit. We'd largely rest on our briefs on those unless there are any questions, but otherwise we'll rest on our brief without any further questions.
Thank you, counsel. We appreciate the arguments. The case is submitted. I'd like to thank our clerks and the court officers especially today, and we are now in recess.